What we are investigating in this case is whether the court-martial is a competent court to try civilians or anybody else brought before it for that matter. Other guarantees of justice and fairness in criminal proceedings are the right to a fair trial and the right to a fair hearing as stipulated under Article 28(1) of the said Constitution, which reads, in the determination of civil rights and obligations of any criminal charge, the person shall be entitled to a fair, speedy, and public hearing before an independent and impartial court or tribunal established by law, close quotation. So the question is, does the General Court-Martial guarantee these fundamental freedoms? The answer, as far as civilians are concerned, has been found to be largely in the negative. In accordance with the doctrine of precedent and in view of an earlier holding by this court, the conclusion in Attorney General versus Joseph Sumushade that the General Court-Martial is indeed a subordinate court as contemplated under Article 129(1)(d) of the Constitution is still good law. Secondly, that Section 117(1)(g) of the UPDF Act does constitute exceptional circumstances under which the trials of civilians in military courts would be justified, and to that extent is not inconsistent with Articles 28(1) and 44(c) of the Constitution. However, I agree that Section 1171(h) of the Act is to be found void for vagueness and therefore inconsistent with Article 28(1) of the Constitution.
The General Court-Martial be substantially composed of civilian judges who are directly appointed thereto by the Judicial Service Commission in accordance with the Constitution, as is presently done in respect of judges of the Industrial Court, and the members of the General Court-Martial from within the military should be appointed in consultation with the Judicial Service Commission. I would so order.
And that only the disciplinary sanctions as described at C above will be imposed by the military courts in those cases. Number two, where a military court determines that the imposition of a more serious punishment, such as imprisonment or a death sentence, is necessary, in addition to removal from service, the military court shall forward the case filed to the Director of Public Prosecutions with a recommendation for institution of criminal proceedings in the competent court judicature.
The General Court-Martial was therefore established as a specialized court of the military forces. On the other hand, the Constitution also establishes courts of judicature empowered to exercise judicial power with various jurisdictions under Article 129 of the Constitution, which states that the judicial power of Uganda shall be exercised by the courts of judicature, which shall consist of A, the Supreme Court of Uganda, B, the Court of Appeal of Uganda, C, the High Court of Uganda, and such subordinate courts as Parliament may by law establish.
Since my brothers and sisters agree either unanimously or by majority concurrence of the orders proposed in this judgment of the Chief Justice, orders are hereby accordingly given in the terms proposed by the Honorable Chief Justice according to that regime. Judgment is delivered at Kampala this 31st day of January 2025. As I said, we intend to obey the soft copies of the judgment. The UPDF is currently being operated under laws and practices which still contain colonial relics in total disregard of the Ugandan Constitution. No attention was paid to this problem when drafting the 1995 Constitution. This court has no powers to bend the Constitution in order to accommodate special needs, whether legitimate or not, of the army. It is only Parliament that has the power to amend the laws, including the Constitution, to accommodate such special concerns of the army. So far, it has not done so. I must therefore stick to only such interpretation of the law that is consistent with the Constitution as it stands now, close quote. The current military courts operate in violation of the constitutionally enshrined and securely protected rights to a fair hearing that are equally recognized universally in conventions and other instruments. Thus, there is need for a robust legislative intervention to ensure the UPDF Act is in accord with the cherished aspirations of the people of Uganda, as was unmistakably captured in the Docket Commission report. In the full judgment, I have to introduce so much of that report extensively. It is therefore incumbent on the executive to generate the policy and Parliament to pass the legislation which addresses and clears the injustice occasioned by the unconstitutional provisions of the UPDF Act, which have now been quashed by providing for military courts that are clothed with the constitutional safeguards of independence and impartiality that are accorded to the ordinary courts. In recognition of the special needs of the military, legislation must be put in place that establishes and confers on the courts martial and tribunals the powers to execute lawful jurisdiction over members of the military, and thus fulfill the function of the UPDF. However, this special exercise of jurisdiction must not infringe on the soldier's right to a fair hearing. The state needs to act in order to ensure that the character of military courts and tribunals meet the democratic standards and aspirations of the people, which are clearly enshrined in the Constitution. It is noteworthy that the court advised in 2009, Uganda Law Society against Karugaba, that the military courts to be truly independent and impartial, there are desirable changes that the executive needs to address in order as follows. In order for this court, in order for this to be applicable to the military courts, the article would have to be modified in such a way as to give the courts independence and impartiality without compromising their military nature. The army would have a parallel judiciary with legally trained soldiers to professionally man the courts. In order to be impartial, the court must have security of tenure and other privileges enjoyed by the other judicial officers in the Ugandan judiciary. It should be noted that the definition of judicial officer contained in Article 151 does not exclude persons exercising judicial power in military courts, close quote. I consider the need for this recommended transformation as relevant today as it was then. In the premises, I would make the following recommendations for consideration by the Executive and Parliament as viable alternatives for the establishment and or creation of military courts in Uganda. These are recommendations. They can pick any, they can reject all, but these are recommendations which the people of Uganda hope to look into. A. Administratively establish the General Court Martial as a division of the High Court without the need to create a new court, with jurisdiction to handle capital criminal cases involving both military officers and any civilians who would exceptionally fall within its ambit, with magistrates within the division handling offences falling under their jurisdiction. B. Limit the functions of the unit disciplinary committees and summary trial authorities to handling strictly disciplinary offences with no power of imposing sentences or imprisonment. C. Utilize the existing magistracy to handle the rest of the criminal cases other than disciplinary offences committed in Uganda, which are currently falling within the docket of the UBCs. The subordinate military courts can handle criminal cases at the level of Chief Magistrate's Court for offences attracting life imprisonment and below. Or D, with the advice of the Judicial Service Commission, appoint civilians with the requisite professional legal qualifications to serve as judicial officers in the current subordinate military courts. They will exercise jurisdiction of offences triable by the subordinate courts. They should have the same privileges and safeguards as their counterparts in the civil courts. Or E, amend the Constitution to establish superior courts within the military court system under Article 129 and clothe them with the requisite jurisdiction and guarantee of independence and impartiality to strike specific military offences of a capital nature and all other capital offences under existing laws committed by military personnel. Or F, provide in the UPDF Act for the High Court to sit as a court martial with power to try all criminal capital offences within the High Court jurisdiction, and those unique to the military that attract the maximum life and death sentences. Grant the Chief Justice powers to assign judges to the military courts. A select number of military personnel can act as assessors. Appeals to the court-martial appeal courts would follow the same format, with the Court of Appeal sitting as such. Magistrates' Court would assume the jurisdiction over all other offences of a subordinate court. G. Make provision in the UPDF Act for trial of civilians in military courts to be only under limited circumstances and only after the state has concretely demonstrated to the court by verifiable facts and by objective and serious reasons the need and justification for recourse to the military court. This must not only apply where, in relation to specific class or category of persons and offences in question, ordinary courts are not in position to undertake such trial. H. Make provision in the UPDF Act for appeal from military courts and tribunals corresponding to appeals in the ordinary courts. In each of the options suggested above, the jurisdiction of UBCS and SDS must be limited to that of tribunals, handling strictly disciplinary offences with no power of detention or imprisonment, as is the case with other disciplined forces, such as the police and prisons. Dated Kampala this 31st day of January 2025, Alphonse C. Owindolo, Chief Justice.
The General Court Martial and other military courts are all subordinate courts. See, Attorney General against Uganda Law Society, Mulenga, Justice of the Supreme Court. However, I do not agree with the finding in the Attorney General of Uganda Law Society that the General Court Martial is subordinate but not lower than the High Court. That is self-defeating, it's contradictory. That it is not lower than the High Court, and enabling it to handle offences at par with superior courts of record. Assigning the ordinary English meaning to the word subordinate, all courts martial are subordinate courts created under 129 1D can only have jurisdiction that is lower than the High Court. Holding that it is subordinate but not lower than the High Court is contradictory. It actually makes no sense. It's illogical, and has the potential to create an absurdity when it comes to the hearing of capital offences. The Parliament desire to grant than the jurisdiction to handle capital cases, then we need to do so in line with the Constitution. In this finding, the hearing by all courts martial of offences within the jurisdiction of the courts of record is unconstitutional under Articles 28.1, 44C, 128.1, and 129D. I hereby find that Section 177, 117H, 1H of the UPDF Act are unconstitutional insofar as they, without qualification, allow for trial of persons subject to military law for civil offences within the General Court Martial and other military court tribunals. Based on this analysis and finding, grounds 1 and 4 of the appeal would fail. Upon examining the objective of the law and the authorities cited, I find that the impugned provisions of the UPDF Act are overbroad and rationally connected to the broader purpose. The trend in democratic dispensations, especially in the new democracies such as Uganda, which witnessed gross human rights violations in the past and reminds itself of its ugly past in the preamble to the Constitution, a sober decision has to be consciously made. Sections 201, 179, now 177, and 119.1H, now 117H, 1H, that allow the trial of persons subject to military law for all offences under other enactments without any qualification is overbroad. The need to maintain discipline is no justification for the trial of members of the UPDF who are within the country by the military courts, and yet there is a functional judiciary. Any disciplinary action on an officer can be effective after a finding of guilt by the ordinary court. I hereby find that sections 2, now 1, 179, now 177, and 119.1H, now 117.1H of the UPDF Act are unconstitutional insofar as they, without qualification, allow for trial of persons subject to military law for civil offences within the General Court Martial and other military courts tribunals. Based on this analysis, as I've said, grounds 1 and 4 of this appeal will fail. Having made the findings that the provisions of the UPDF Act that confer powers on the military courts to exercise judicial powers are unconstitutional, there arises the consequential issue of the fate of those who at the time of this decision on unconstitutionality of the UPDF Act are facing charges or undergoing trial or have been tried and convicted before or by the military courts. This issue was neither raised nor canvassed at the hearing of the appeal. So this court has not had the benefit of counsel's opinion on the matter. Nonetheless, it is a matter of great public interest, hence this court has to deal with it. Issues concerning the extent to which judicial adjudication has retrospective effect, especially regarding the finding that a law or act is inconsistent with the Constitution, is not novel. See Duke Mabea and A against the governor of Abba Hill Prison, whose citations are given. Two rules have been developed which have gained universal recognition and application. First is that once a law has been declared unconstitutional, then applying the principle of direct review, the declaration has a force of retroactive application. Where, however, the accused person was convicted under a law that is later declared unconstitutional and has either exhausted the appeals or has not pursued any appeal, the matter is taken to have been concluded. In such circumstance, the declaration of unconstitutionality of the law has no retrospective application. In retroactive application of new rules, there is a difference between civil and criminal cases. We are here concerned with the latter. Whether a decision announcing a new rule should be given prospective or retroactive effect should be determined at the time of that decision, as this one here now. Thus, there is a further difference between criminal cases on direct review and those on collateral review. Direct review concerns those criminal cases where the person seeking relief arising from the new rule has not yet been tried, is undergoing trial, has been convicted but is still pursuing a direct appeal, while collateral review refers to those cases where the criminal defendant has exhausted all direct appeals, if any. I cite the authority responsible. In Uganda, the Constitutional Court in Mabea case and American jurisprudence late letter case cited, United States Johnson case, Griffith Kentucky case, Stovall Delaware case, and the court cited this and came to the conclusion that retroactivity should depend on one, the purpose of the new rule, two, the extent of reliance on the new rule, and three, the effect on the administration of justice of the retroactive application of the new rule. The decisions following late letter laid down how this rule would apply to pending cases and those on appeal under direct review. The current American position elucidated in a nominated constitution prepared by Congressional Research Service at the Library of Congress and quoted in A against Governor of Aberhill Prison, stated as follows, open quote.
The general rule is that new rules of constitutional interpretation announced after the defendant's conviction has become final will not be applied. Thus, application for habeas corpus based on a judicial decision subsequent to a conviction becoming final and not otherwise under direct appeal or review fall into the category of collateral review and therefore not entitled to rely on new rules of constitutional interpretation. This principle is apparently not novel to our modern time, as Cicero is credited with having coined the maxim, summum ius summa injuria, variously translated but classically as the strictest application of law is the greatest injustice. This general principle regarding the effect of declaring a legislation unconstitutional was succinctly stated by Murray J. in A against the Governor of Aberhill as follows. In a criminal prosecution, where the state relies in good faith on a statute in force at the time, and the accused does not seek to impugn the bringing of or conduct of the prosecution on any other grounds that may be in law, open to him or her, including the constitutionality of the statute before the case reaches finality, on appeal or otherwise, then the final decision in the case must be deemed to be and to remain lawful, notwithstanding any subsequent ruling that the statute or a provision of it is unconstitutional. The learned CJ explained the meaning of the collateral attack as follows. A collateral attack arises where a party, outside the ambit of the original proceeding, seeks to set aside the decision in a case which he has already been finally decided. All legal avenues, including appeal, have been exhausted, for reasons that were not raised in the original proceedings, but for reasons arising from a later court decision on the constitutionality of the statute. We made a comparative survey and review of various jurisdictions on the issue and found commonality in the decision taken by them on it. That said, the question of retrospectivity in the form raised here is one which is material to all legal systems. The fact is that at no stage during the course of the hearing in this case was the court's attention drawn to any system of justice in which a finding that a law is unconstitutional, even where this is deemed to be so ab initio, meant that previous and final judicial decision based on such a law must inevitably be considered unlawful and of no effect in law. I'm not aware of any legal system with that effect. Referring to the situation obtained in the US, said There are transcendent considerations which militate against complete or absolute retrospectivity. Fundamental interest of public policy requires limitation on the retroactive effect of judicial decisions. The legal order and the administration of justice is not one perfect symmetry. As Justice Benjamin Cardozo observed at page 161 in his seminal work, The Nature of the Judicial Process, Yale University Press, 1921, we like to picture to ourselves the field of the law as accurately mapped and plotted. We draw our little lines and they hide it down before we blur them. Although judicial adjudication do not have retroactive effect, there are important exceptions and restrictions to that effect.